Hello everyone, welcome to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. Authorization for Maritime Law Enforcement Operation. In March 2016, the Argentinian Coast Guard fired upon a Chinese fishing vessel allegedly engaged in illegal fishing within the Argentinian exclusive economic zone. The incident led to the use of direct fire to halt the delinquent vessel, which ultimately sank. That the use of force in maritime law enforcement operation result in the sinking of vessel is unusual. That this level of force is routinely employed in maritime law enforcement, however, is not. And whilst the ultimate outcome, firing at or into a delinquent vessel, is an act that straddles both maritime law enforcement and naval warfighting, the legal basis that govern these two maritime operation regimes are radically different. Maritime law enforcement comprises those actions, including investigation and prosecution, taken to enforce all applicable laws regarding conduct or consequences on, under and over international waters and in waters subject to the jurisdiction of the state carrying out those enforcement activities. Maritime law enforcement, therefore, presupposes authorization for law enforcement agents and authorized vessels to deal with other vessels and the people and cargoes within, including in many situations, foreign vessels and nationals, by taking action at sea and subsequently ashore in order to enforce the relevant laws. Maritime law enforcement may be employed either where the breach of laws is committed at sea or where the reach of the state extends to apprehension at sea for an offense committed ashore or elsewhere. An example of the former situation is apprehension of a vessel in a coastal state's exclusive economic zone for illegal fishing. An example of the latter is a situation where the relevant states have cross-faced jurisdiction to each other to halt a vessel suspected of carrying a person subject to an arrest warrant for a terrorist act committed ashore. The purpose of this article is to focus upon this legal framework applicable to routine maritime law enforcement in order to provide a sketch of what lays on the other side of the dividing line between maritime law enforcement and international humanitarian law, or IHL, at sea, or the law of naval warfare, to the extent that this line is capable of detailed delimitation. Maritime law enforcement, as with other forms of Maritime law enforcement, as with other forms of policing, is a highly interventionist process. Basic maritime law enforcement authorization generally include powers to undertake action such as signaling, stopping and boarding suspect vessel, searching suspect vessel and the people and cargo in such vessel, detaining or arresting people in suspect vessel and or the suspect vessel itself, seizing items non-suspect vessel, directing or steaming suspect vessel and the people and cargo in those vessels to a coastal state port or a similar place for investigation, to conduct of that investigation and subsequent prosecution or imposition of other forms of administrative action or sanction. Maritime law enforcement, therefore, requires that a number of preconditions be in place before conducting operation. where the focus of maritime law enforcement is upon interference with foreign vessels for law enforcement purposes. These preconditions include that, first, the coastal state has enacted a law that applies to the conduct with the maritime law enforcement agent in using as the basis for their action in relation to a particular suspect vessel. Second, the coastal state has authority to regulate that conduct in the maritime zone where the suspect vessel is located. Third, the maritime law enforcement agent is authorized under their coastal state's law to take maritime law enforcement action against that suspect vessel in relation that suspect breach it to that suspect breach in that maritime zone. And fourth, there is no legal limitation or, for example, a constitutional limitation for jurisdiction, a constitutional limitation of jurisdiction to a narrowly defined concept of territory, to the application of the coastal state's law to the vessel and people that are the target of the coastal state's maritime law enforcement action. It is therefore fundamental to recognize from the outset that maritime law enforcement is at one level simply a routine peacetime policing operation, or, as it often referred to in the maritime domain, a constabulary operation. In that the determination of jurisdiction and authority is a necessary first inquiry. In other words, there is no role for international humanitarian law in routine maritime law enforcement. That said, as other contributions in this issue of the review well illustrated, there are multiple points at the fringes of maritime law enforcement where international humanitarian law can and does come into play, and some of this will be noted in the final section of this article. As noted above, limitation of space and reader tolerance and the availability of excellent scholarship on the major aspect of maritime law enforcement dictate that the aim of this article is to restrict to a brief, selective, and necessarily summative description of the threshold matter of possible legal basis for maritime law. Possible legal basis for maritime law enforcement action. There are, consequently, two limitations on the scope of this article that must be clearly acknowledged up front. The first is that there are, of course, several other vital matters that would need to be addressed in any comprehensive elaboration of the maritime law enforcement legal authorities framework. Self-defense and use of lethal force in maritime law enforcement, as distinguished from use of force for maritime law enforcement purposes outside immediate self-defense. The requirement for clear elucidation of rights, powers, and obligations for maritime law enforcement agents in national laws, the appropriate domesticization of offense in national law, the right of hot pursuit or a key maritime law enforcement power, the interaction of law enforcement and human rights at sea, and the series of cases and incidents that have defined the limits of use of force in maritime law enforcement are but some examples. The second limitation is that although maritime law enforcement is fundamentally a policing activity, the source of authority for maritime law enforcement operations are significantly wider than those traditionally understood from and grounded in criminal or administrative law and offense. Indeed, one of the complicating factors affecting maritime law enforcement much more pervasively than policing ashore if this venue enable myriad of sources of legal authority. Nothing, of course, that implementation of an international maritime law enforcement authority still requires appropriate incorporation in national law in order to appropriately empower a state's maritime law enforcement agents. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.